Good evening to the participants of the SLW648. Karibu sana. Welcome to my online class that is set to be the virtual class of the private international law. And today is the maiden attempt, the first class, which I am going to deal of this semester. Yes, anyone can unmute and read what I posted on the screen so that I know that you are with me and I am with you. Both are traveling the same boat, are sailing the same boat to reach to the destination. Anyone? Unmute and read. Okay, let me read it. It's a private international law, and here the abstract which I have given here is globalization has encouraged the proliferation of the private international law making at national, regional, and global level. Beginning the national, next regional, next global levels, private international law governs the choice of law, and it is a choice of law to see that which applicable law will be applied in particular case when the cause of action arises. To apply when there are the conflicts in the domestic law of different countries related to the private transactions. And the private international deals with the private transactions. At that instance, there are the two parties, one party from the one country, another party from the another country, and the conflicts comes over there, which applicable law could be used, whether the country A, that is the Tanzania, whether country B, Kenya. That is the conflict over there, which legal system could be applied for the resolve the legal disputes. Or what jurisdiction applies regarding the choice of court, whether the which country is having the choice of the court, whether the Tanzania is having the jurisdiction or the Kenya is having the jurisdiction, when the party hailing from the two different countries, and the conflict or the breach is happened in the Tanzania at the time, cause of action arises in the Tanzania, and the Tanzania domestic law would be applied over there because Lex Law C is applied because these are the connecting factors you can come to know in the later part. And the renvoi also there, transfer of the proceedings and recognition or the enforcement of the foreign judgment. Renvoi, the pronunciation is R-E-N-V-O-I, renvoi. And I give the reference and you give the reference. I respect your judgment and you respect my judgment. That is called the renvoi. And you will come across the renvoi when you go in further classes. And recognition of the enforcement of the foreign judgment. If any judgment is given in the Kenya, can it will be recognized and enforced in Tanzania or not? At that instance, the doctrine of renvoi will work over there. If the Tanzania will give the reverence and the respect to the Kenya judgment, at the same instance, Kenya also give respect to the Tanzania judgment. That is the give respect and the take respect. That is the doctrine of renvoi. And then you can say enforcement of the foreign judgment. National laws are the primary source of the private international law. There is no new law is there in the private international law. It is a domestic law only. But when and where one should have to use the domestic law. Whether the justice will be given if you use the domestic law or not. And generally the private international law, a person who goes to the tap the door for getting the justice in the private international law, and the judges will see that he should not go with the empty hands. That is the general principle. Another point is there is no hard and fast rule because in the same facts of the case sometimes the applicable law is different, and same the facts of the case is applicable law is different because they see the rationality. And by seeing the rationality, the judgment will be given by applying the which will be the connecting factors and what are the theories should be used over there and what are the canons should be used over there. Depending upon that factor, they will take into consideration. That is the whole idea behind the private international law. When you see the introduction, private international law or international private law governs the choice of laws to apply when there is a conflict in the domestic law of different countries related to the private transaction. Why the conflict comes here? The reason is one party from the one country, another party from the another country. And when the private transaction is taken place, at that instance, if there is a breach of a contract, for instance, you take it. At that instance, for the breach of a contract, which country is having the jurisdiction to entertain such a case? Number one. Number two, what is the lex causae? What is the applicable law? The legal system could be applied. Either the Tanzania domestic law or the Kenya domestic law if the party hails from the two different countries, that is Tanzania and Kenya. Are you hearing me? Say yes. Ilianoa, unmute and say yes. Yeah, keep the gadget very near to your mouth, then you can speak. Then mute. Okay. This means you read this thing, what I highlighted here. Unmute and read.
Okay, private law or international private
I say
law governs
highlighted.
the choice. Okay, this means that there is a dispute or transaction that involves one of the following: what jurisdiction applies, choice of court, forum selection, renvoy, or in brackets transfer of proceedings, choice of applicable law, and recognition or enforcement of the foreign judgment.
Yes. See, these are the components one should have to study. This means in the private international law, what you are going to study is when the conflict or a dispute in the transaction that involves one of the following elements. Because in private international law, generally there are two elements are there, and these two elements, I mean parties, are different countries. Suppose if the conflict arises between the parties, those who are staying in the Mwanza and those who are staying in the Arusha, do you say it is a private international law conflict?
No, sir,
Why?
because they're in the same country.
It is the same country. In the same country, it is intra conflicts. But in the legal system of the country is different. For instance, customary law is there and statutory law is there. When such a conflict comes over there, generally statutory law will prevail over the customary law. Or general law will be eclipsed by the special law. So that is a different issue again. Now, when the matter comes to the two parties, one party from one country, another party from another country, at that instance, what is the jurisdiction applies? For instance, whether the Tanzania jurisdiction will be applied or the Kenya jurisdiction will be applied. When one party from Tanzania, another party from the Kenya. And for instance, contract. Now, because of why the private international law is very much famous now, earlier it was only elective course. When I joined in the 2004 in the University of Dar es Salaam to teach, and it is restricted to only the prospectus. No one is teaching the private international law there. Only prospectus it is there, private international law as an elective course. But at the time, the dean is Professor Ibrahim Hamisi Juma, the present CJ of the Court of Appeal. And he asked me, Hussain, which subject that you are very much comfortable? Then I said, my pet subject is law of tort. And I taught this private international law in the University of Asmara, Eritrea, Northeast Africa for the 3 years before I joining the UDSM. That's why I have picked a private international law. It is me who made the prospectus, and it is me who made from the prospectus to the teaching line. At the time, it is an elective course. For the 3 years, I taught as an elective course. But later on, because of the globalization and liberalization, the world is now only on the palm, like a Hamlet. Because of that thing, the TCU. What is TCU?
Tanzania Commission of Universities.
Tanzania Commission for the University, they filed, no, this should not be an elective course. This should be a compulsory course. Then, at that time, elective only 10, 15, 18. But when became a compulsory course, it is there at the time, 420 or 440 students are there in the final year, first semester. That is the fourth year, first semester. And those who opted the elective, they are exempted. And those who did not do it for international, they did it after the fourth year, fifth year. I am the pioneer. I am the founder to start the private international law in Tanzania. Give a big clap.
Yes, I heard you, sir.
Give a big clap. I did not hear the clap.
Yeah?
Clap, you know, clap.
Yes, I just clapped.
But I did not hear it. Did you hear the clap?
Yeah?
Clap, did you hear?
Yes.
Clapping. This is the clapping. Is it clear?
Yes, sir.
Okay, now, national laws are the primary source of the private international law. Domestic law is the primary source of the private international law. The scope of the private international law varies from country to country, and each jurisdiction has its own rules. And in the United States and Canada and the Great Britain, the term conflict of laws is more popular. But we, because of the common law countries, we don't say conflict of laws. We say the private international law. Deals with a variety of the topics such as the international contracts, or the international contracts means contracts between the two countries. Is it clear?
Yes, sir.
And the torts, that is called a lex loci delicti, and the family matters. What are the family matters?
Divorce, matrimonial property, and others.
First and foremost, marriage. Next, adoption.
Divorce.
Marriage only, divorce, no children.
Yeah, the issue of children also.
Marriage, children, adoption, divorce, maintenance, then inheritance, transfer of property,
Yes,
movable
sir.
property, immovable property, wills, child adoption, abduction, allotment, real property, lex loci situs, intellectual property. In addition to the rules by the made national authorities and treaties, bilateral treaties, multilateral treaties, modern laws, connecting factors, renvoy, and other instruments have been brought in by the international organization to regulate the area of transnational disputes. Certain things are there, like arbitration. International arbitrations are there, where the Tanzania also party and the India also party, even the Kenya also party. So when the international transaction of the arbitration is there, generally that we follow those laws, bylaws, which are there in the international treaties. Is it clear?
Yes, sir.
The International Institute for the Unification of the Private Law, UNIDROIT, they want to make it a uniform law so that the things move in a common direction, in a development direction. So the Hague Conference was made on the private international law, and they formulated and they are codified some of the matters regarding the disputes are concerned. The Hague Conference has been impressive growth of both its member and the range of the states parties to its conventions. The Hague Conventions, the Rome Conventions, the Berne Conventions, and like that, there are few notable conventions are there, say about 7 to 8. And these 8 conventions, we have to read it. Each convention says about particular aspect of it. So globalization and liberalization made the private international law to be studied as a compulsory course, as a core course. And this will be studied only in the last year, first semester. The reason is,
I didn't understand you, sir.
if you don't know, you say pass on.
Pass on.
The reason is, what it deals about the family law, it deals about the transfer of property, it deals about the contract, it deals about the arts, and these are all the things you studied in the first year, second year, third year. And if it is the fourth year course, the fourth year first semester would be there, so that you cannot keep a zero face when the matrimonial case are going on. And you cannot keep the zero face or a withered face or a pale face when tax cases are going on. Is it clear?
Yes, sir.
These are all the courses that you will study by that time. Hence, it should be the final year first semester. But I wish that it should be the 2-semester course. For instance, you take the Ruku, it's a 2-semester course. But I introduced it in the beginning as a 1-semester course. But later, I proposed it for the 2-semester course. But later on, I did not get the renewal. Then I went to the India. But I will suggest in in South that it should be studied the 2 semester course. I would like to make a proposal when a thing arises. Now let us come to the point. It is the 1 semester course and it comes in the 4th year, 1st semester, and where we studied it. And by that time you will study the public international law also, where we can come across the international treaties and charters, other protocols and declarations, all those things. So Organization of the American States, this is one of the organizations like UNIDROIT. They also try to make the uniformity in the private international law. And Mercosur have adapted the wide range of the private international law instruments while in Europe. And the European Union also acquired a power to legislate in the field of the private international law. So at least the main 3 organs are there. One is UNIDROIT, that is the unification of the private international law. Another is the OAS, that is the organization of American states. Then the European Union. Of course, AU also made certain attempts to see the uniformity should be made. AU means
EU,
AU.
African Union.
What is the earlier name of the African Union? OAU. Organization of the African Union.
Organization of Africa Union, yeah.
Yes, has acquired the power to legislate the field of the private international law. Now, private international law is a very flourishing subject, very interesting subject, because, sir, I born in Monza and I die in Monza. Is it?
Okay. Yeah.
Yeah. Now the world is on your palm. You grow in Tanzania. You marry in Canada. You did the job in the America, and you transferred to the New Zealand, and you have the business in the Australia. Are you following me?
Yes, sir.
And your sons will marry to the different country people, and there is a lot of now the world becomes a planet Earth. It is on your palm. Morning breakfast you take in one country, and lunch in another country, in the dinner in another country, and daku in another country. What is daku?
Parcels, I don't know.
Daku means the Muslim faith people, those who eat in the early hours of the dawn at 3:45, 4 o'clock, 4:30, the meals, it is called daku. Futuru?
Futuru is the one that is eaten after fasting.
Breaking the fast.
Breaking the fast, sir.
And starting the fast, daku. After eating.
Okay.
So, you eat the daku in another country, and futuru in another country. Are you following me?
Yes, sir.
Thus, there is a lot of interaction would be there. And if any country should be grown, it should be have a good relation with the neighboring countries. Is it clear?
Yes, sir.
So, a good reverence would be there from both the countries. I respect your judgment and you respect our country's judgment. That is called renvoy. Giving the respect. If any person go from let us say Moshi to the Bukoba, and in the Bukoba people offer sanene. Am I right?
Yes, sir.
And if the Bukoba people goes to the Moshi, what they offer?
Moshi banana.
Indizi.
Yeah.
Yes. Suppose that is called
Yes,
the
sir.
reverence. Give respect and take respect. And the same way,
Yeah.
each country will give the respect of the judgment of the another country. The another country also give the equal respect to the country. That is called recognition, enforcement of foreign judgment. And the private international law. Yes. Do you want to ask anything?
I was just trying to ask for you to repeat the latest point you have just made.
Yes, I give respect to your country decision, judgment. You respect our country judgment. That means recognition and enforcement of foreign judgment. I repeat,
Okay.
recognition and enforcement of foreign judgment.
Foreign
Instead of
judgment. Yes,
wasting the
sir.
time, the same factors are there and same facts are there. The judgment which is given by the Kenyan court, competent court, will be equally valid in the Tanzania because general principle of contract are the same. The reason is both countries are ruled by the Britishers, means colonies, and hence we can use as it is the judgment, provided the conditions are there. You can use the foreign country judgment provided you should not be any controversy with the constitution of Tanzania, number one. Number two, the existing laws in the Tanzania. Number three, the policy against the policy of the Tanzania. Number four, a competent court has to give such a judgment and that to be without any fraud and coercion and fairly. Then such judgment can be identified, recognized, and enforced in Tanzania. Simultaneously, Tanzania judgment will be recognized and enforced in Kenya, provided if they follow the Renwai. So, available in the Peace Palace Library, both print and electronic format, and handbooks, leading articles, and both in the bibliographies, periodicals, serial publications, document of interest, selective bibliography. Of course, they are the libraries which are holding a lot of material, especially in the International Court of Justice. Where is the International Court of Justice? Sema sijui.
International Court. Sijui, sir.
International Court of Justice is there in the Netherlands and it is situated in the Peace Palace in The Hague. Repeat.
It's situated in The Hague, Netherlands.
Building. Gorakha.
Excuse me, sir?
Peace Palace Library. There is a Peace Palace where the ICJ is there, International Court of Justice in The Hague.
Okay.
And the same way, in the same place, Netherlands, Hague, International Criminal Court also there. It is one of the
ICC.
special organ of the UNO. But ICJ is the sixth organ, one of the main organ of the UNO. How many organs are there in UNO?
Pardon me, sir?
How many organs are there in UNO? United Nations Organization.
Organs, there are like five organs.
Six.
Yeah, six organs, yeah.
What are they?
There's a Security Council, General Assembly, Trustship Council, Economic and Social Council,
Tosha.
yeah, we have the others, but it's hard to recall right now.
Yes, all the five organs there. Where is situated five organs?
Repeat the question, sir.
Where all the six organs there? How many organs?
Other organs?
All 6 organs are there. See, the main body of the United Nations are the number 1, General Assembly. Number 2, Security
Yes.
Council. Number 3, the Economic and Social Council. Number 4, Trustship Council. Number 5, International Court of Justice. And Union Secretariat, another is. All 5 are in New York. Only one organ is Netherlands, The Hague. That is ICJ. Is it clear?
Yes, sir.
Now, how many organs are there now?
There are 6 organs.
What are they?
General Assembly, Security Council, Economic and Social Council, Trustship Council, UN Secretariat, and ICJ.
Based in the UN headquarters in the New York. All 5. But only one organ is there in the International Court of Justice, is located at The Hague in the Netherlands.
Yes, sir.
Is it clear?
Yes, sir.
Good. Appreciate. So, now, when you want to study the private international law, you have to keep in the mind what are the things should be there to study. We don't study the different law. We study only the municipal law. Private international law has its historical development in civil law. Is it a civil law, not a criminal law? For instance,
Okay.
assault battery will not be dealt. Yes, it can be entertained definitely by the states when they approach to the International Court of Justice. International Criminal Court. Like Putin made the bombarding on the Ukraine and somebody filed a case in the International Criminal Court. International Criminal Court made a summons to the Putin to present his case. If not, they will take action. Even the UNO Security Council will interfere in the matter and they make an economic sanction against the Russia. Are you following me?
Yes, sir.
Lex 4E, law of the forum, is the law of the forum, and lex causae means is the law of the law of the cause, means law of the matter in disputes. So it is sometimes called the dispositive law as opposed to the procedure law. Dispositive law means substantial law. Procedure law means Sema.
I cannot recall, sir.
Substantial law shows the rights and the punishments. The procedure law shows how it can be implemented, the procedure to follow. Is it
Yes,
clear?
sir. Yes, sir.
Now, here it is given AB, both resident in the Brisbane, have a dispute over the ownership. Is it a private international law? Answer is no. Because both the parties from the same?
Country.
Okay, now I will give an example. A man from the mainland of the Tanzania having the contract with a man who is there Zanzibari. And there is a legal breach of a contract is made. Is it a private international issue?
Can you repeat the question, sir?
A man from the mainland of the Tanzania had a contract with a man who is a Zanzibari from Zanzibar. And there is a breach of a contract. At that instance, can it will be a private international dispute?
No, sir.
Why?
Because we are united in the matter concerning foreign affairs.
It is one of the country. Both amalgamated Tanganyika and Zanzibar then
and
become
Zanzibar.
Tanzania.
One, yeah.
Of course, regarding the administration is concerned, presidents are different, legal system is different, but the currency, union matters are the same, state matter refers. Is it or not?
Yes, sir.
Yes, here the law of Queensland, Lex 4E, substantial law relating to the matter is a property, Lex cause, and procedure law is the civil procedure or evidence. Procedure law is followed of that country where the case is instituted. Regarding the substantial law is concerned, it is based on the lex causae, where the cause of action arises. Depending upon that factor, the substantial law of the other country can be used as it is in the local country. Then only it is a justice to the parties. If not, it is not a justice to the parties. So that was the thing which you want to make it out. Gay marriages are allowed in Tanzania.
No, sir.
But allowed in the South Africa.
I've not made a follow-up yet, sir.
In South Africa, gay marriages are there. Hawaii, gay marriages are there. Miami, gay marriages are there. Some countries are, they gave the green signal. Can the two Tanzanians go to the South Africa, gay, marry each other, and come back to the Tanzania and they say they are the wife and husband?
No, because it will be in conflict with our law.
The question comes, when the Tanzanian domicile go to the South Africa and get it married, it is nothing but disguised form of marriage, validity, and hence, if they want to stay in South Africa, let them stay, but they are not supposed to be back to the Tanzania because Tanzania legal system will not allow it. Moreover, in the South Africa, when they want to get married, the South African court will say, are you a domicile of South Africa? They say no. Do your country allow the gay marriages? They say no. And then South Africa says, we don't allow you to get married. But you can get married, you can forego the Tanzanian domicile and acquire the domicile of South Africa. Then when you become a domicile of the South Africa, but foregoing the domicile of birth, at that instance, you can have a right to marry and stay over here. Is it clear?
Yes, sir.
Otherwise, one cannot go to the South Africa and get married and come back and say we are the wife and husband in the court of law. Answer is no. Because any country where you got to marry, first and foremost, they will ask your domicile. In the marriage, domicile plays an important role. In the law of taxation, domicile plays an important role. Depending upon the domicile, the tax should be paid. Depending upon the domicile, the marriage contract should be held. The reason is, the correcting factor is lex loci celebrationis, means the law of the place where the marriage is celebrated. In the law of the place where the marriage is celebrated is a valid law, but before it could be going to be a valid law, it should be prerequisite is their domicile will allow such a marriages or not will be considered. Otherwise, everybody go and marry there and come back and lead their life. So, that is not the way. Suppose if you want to marry more than one wife, you convert yourself totally to a Muslim and then go for the marriage. But only for the sake of marriage, if you convert yourself, but not followed all the tenets of the Islam, then it is a disguise form that you get it married. It is amount to the bigamy. Is it clear?
Yes, sir.
So, when you want for the conversion, let you convert totally, but not for the sake of marriage. Is it clear?
Can you repeat that, sir?
Yes.
Can you repeat the last statement?
Last state means if you want to get married more than one wife, you have to convert into the Islam in total, not for the sake of marriage. You have to convert yourself and follow the tenets, means religious rituals of the Islam. Offer the 5 times prayer. Make the Sawm in the Ramazan. Make the Zakat. All the pillars of the 5 should be followed. Then only completely you converted. At that instance, to whom that you are going to marry should also be in Islam, and you can have 4 marriages at a time. Did you see anywhere the person having the 4 wives now?
No, not unless he is a Muslim.
Even a Muslim also, did you see in the Monza having the 4 wives?
I've witnessed some of the people who has 4 wives.
They are on the fingers. They are on the fingers to count. The reason is 1 wife is equivalent to 4 wives now because of the economic factor. Is it clear?
Yes, sir.
Because of the economic factor, 1 wife is equivalent to.
Okay.
1 wife is equivalent to 4. Arbaini. Tatu inne. Moja imke equal to inne imke sasnevi. Iliopita, they are very strong, economically sound, biologically sound, in all respects sound, they can go. But now, 1 is equivalent to 4. Say, 1 is equivalent
to 4.
Yes. That means you are following me and I am following you. Both are sailing in the same boat to reach to the Inguja. Najua Inguja?
Yes, sir.
Ukawapi?
Along the Zanzibar island.
Okay. How many islands are there in Zanzibar?
3.
What are they?
Mafia, Unguja na Pemba.
Okay.
Mungu ibariki Tanzania, dumisha uhuru na umoja wake kwa waume na watoto. Mungu ibariki Tanzania na watu wake. Ibariki Tanzania, ibariki Tanzania, tubariki watoto wa Tanzania.
Sikiliza mimi darasa, asante sana na shukuru sana. Mungu akubariki na kukulinda.